Hi, everyone. Harry here to talk about an opinion by a district court judge in more or less the same situation, if anything, a better situation for the administration in Los Angeles as exists already in New Jersey with Alina Habba, and more importantly, the Eastern District of Virginia with Lindsay Halligan, in all three of which defendants have challenged the legitimacy of the appointment of the U.S. attorney and indictments signed by them in trying to say you should dismiss our indictments. And of course, that's the exact factual scenario as exists for the indictments of both Tish James, the AG of New York, and Jim Comey. In both cases, Lindsay Halligan alone in the grand jury, a bizarre and very unusual occurrence, by the way, for the U.S. attorney to be alone in the grand jury. I was the U.S. attorney. It would have never, ever happened, and I knew what I was doing, unlike her. But she's the only one there and the only one who signs both indictments. And that matters because, and now let's move to Los Angeles, the U.S. attorney there named Bilal Asaili was involved in a case in which defendants have challenged the lawfulness of his appointment. But in that case, the indictment was signed. He's just on the signature block, as is true of all filings in a U.S. attorney's office. And there were three other AUSAs. That matters because of the remedy that the district court here ordered. So let's move to the district court opinion. And it's actually by a judge. Technically, well, the judge is in Hawaii. That's in the Ninth Circuit, but not the California Central District. And that's because, as with Eastern District of Virginia, where Judge Nachmanoff has assigned it out, the same in New Jersey, there's a recusal because the district court judges deal every day with the U.S. attorney and people from their office, and it would just be an appearance of a conflict for them to boom at a stroke, get rid of the head of the office and cause trouble for so many indictments. Okay. So on the one hand, and I've said this before, you have a pretty complicated regulatory and statutory scheme. The big statute here is the Federal Vacancies Reform Act. But rather than, go through with your, with graph paper and pencil, the point to understand is this is passed by Congress, the whole scheme to prevent an administration from doing an end run around what otherwise would be the Senate's authority to confirm U.S. attorneys. So when someone has been an interim U.S. attorney, they can do that, but only for 120 days. And then the court is supposed to appoint a successor. Then there's the possibility that, well, first there's the possibility that the administration actually confirms someone, which they haven't been able to do here, which is what triggers it all. Then, if they haven't, you can have a so-called acting U.S. attorney, but that person has to be already confirmed by the Senate, or there's a couple other things they can be, again, without having to go through into the weeds here. The notion is the administration shouldn't be able to just put a stranger in there to act, and the Congress or the Senate never give its input. So in this case, the two defendants who were convicted of crimes where the U.S. attorney, the acting U.S. attorney, Asaili, signed the indictment, but only as one of four. Not even signed, really. It's the block on top that, and then by these three AUSAs. The two defendants challenge, and the challenge goes to a judge in Hawaii, Judge Seabright, who says, you're right. Here's the way it works. They have violated the scheme, and these indictments are just unlawful. You hit the head of the interim period, and you can't just make this guy the interim U.S. attorney. That's a special designation for a special part of the Vacancy Reform Act. Now, what's that mean? That means he goes back to being the acting United States attorney. That's not supposed to be extended in perpetuity, but at least that's the kind of crowing sounds that the U.S. attorney is making as of this morning. He says, it won't change anything. I'll still exercise all the authority. We'll see about that. We'll see whether subsequent defendants challenge it. But the main point is when it comes to remedy, this court, Judge Seabright, agrees with Asaley, agrees with the United States, and says, yes, he was not validly appointed, but he's not the only one who signed the indictment, and therefore I'm not going to dismiss the indictments because they were signed by other attorneys for the government, and there's been no showing of irregularities. In the Third Circuit case involving the New Jersey case, Alina Habba, you had a judge saying you really can't unscramble the eggs. Her signature is on it. That means the indictment should be dismissed, but they can be refiled. Okay. What does all this mean for the most important cases where this claim has been raised, namely the charges of selective prosecution and the illegal appointment of Lindsay Halligan in the Jim Comey, Tish James cases? And there it's interesting. So on the one hand, this is Lindsay Halligan, definitely fails the test. She is just stuck in there, called the U.S. attorney, but the interim had already been, the 120 days had already run. They can't put her in. She's not one of the 3 people designated. It's an end run around it. And I mean, we will see the case has now gone to a judge out of the district who, and I had another YouTube about this yesterday, very interestingly, and I think it's going to portend a battle with the Department of Justice. That judge has said, give me all the information, all the signal chats, everything involving Lindsay Halligan's appointment to do these cases. But assuming the judge finds that it was unlawful, and not to do it would be to be out of the what is now the holdings of both the courts to have considered it. Assuming he does, the difference here is she's the only one who signed it. So that means still, possibly in remedy, he decides, as some courts may, you can still salvage the case, but go back and do a new grand jury. And that's for Tish James. For Jim Comey, I think it's different. We'll see how it plays out, and if there's some effort that the United States even makes to salvage it if it turns out that Halligan has been unlawfully appointed. But recall, they shoot her into office quickly and pushed her into the grand jury room when she didn't know a thing about what she was doing and never been in a prosecutor's office, because the statute of limitations was about to run on Comey's asserted crimes, which are pretty darn weak in their own right. But anyway, if this indictment turns out to be invalid because she's invalidly appointed, and I don't see any way it can't be if she's invalidly appointed, I don't, absent some extraordinary grant that I think itself would be subject to legal challenge, I don't see how they re-indict Comey, and that might be the short end of this long drama. It wouldn't be a jury verdict, which Comey would clearly love to really stick it to the administration, but it would be a very definitive and embarrassing, a debacle really, put down of the department for having been so foolish as to put her in after they already knew about Alina Habba, already knew about the problem, and then to have her go to the grand jury alone. So stay tuned for that and the application. We already have that process underway by the judge in the Comey and James cases, where the motions that to find her unlawfully appointed were combined, have been consolidated. So we'll learn what the judge has to say about that, and maybe most importantly, what remedy in the event Halligan has been unlawfully appointed, as it sure looks that she has been. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.